dive in. Thank you all for joining us today for our webinar on the E-2 visa. My name is Dustin Saldarriaga, and I'm a senior associate at Scott Legal PC. Today's presentation, we're going to focus on what is probably the most common visa that we help our clients navigate, the E-2 visa. It is a wonderful visa for individuals who are from an E-2 treaty country. We'll talk more about what that means. Our firm has a very personal relationship with this visa. Our firm was actually started on an E-2 visa by our founder, Ian Scott. And there's good reason for that. It's a wonderful option, particularly if you are looking to invest a relatively low investment amount, but you're looking to grow a business in the U.S. that will employ U.S. workers. The fact that we have navigated the process personally also informs the way that we work with our clients. And I will just note that our founder, in addition to the E-2 visa, Ian has navigated the F1, the H-1B, TN. So we do know the process quite personally. Our firm is a full service immigration firm. So we do handle family immigration, we handle litigation against the government, we handle temporary visitor visas, student visas, really the full spectrum of US immigration. So if you have a question or a need that's related to US immigration, we do hope that you'll reach out to us. After this presentation, you'll get an email with a link to our YouTube channel. We post all of our full-length webinars on our YouTube channel. And we also post shorter videos on a variety of topics. So we do hope you check out our YouTube channel and find those helpful. We'll also send you a comprehensive guide to the E-2 visa, and we'll send you a copy of this presentation that you see on your screen. So no need to take extensive notes. We will also send you a link to our website where you can schedule a consultation to ask questions that are specific to your circumstances. And another resource we have on our website is our blog. We have thousands of posts on our blog. Again, we take great pride in those. We try to put very good information out for free. So do check that out. If you have any questions during this presentation, we do plan to get to those by the end. We'll probably save all questions for the end, but don't hesitate to send them in. If you have a question, please share it with us using either the chat function on Zoom or the Q&A function on Zoom. And again, we'd be happy to answer those toward the end of the presentation. I am very fortunate to have my colleague Jiyae Hwang joining us today. Jiyae has extensive experience on a variety of green card and non-immigrant visa options, including the E-2. Jiyae is a fellow senior associate at the firm. So she is going to handle the first half of the presentation, and then I will handle the second half. So without further ado, I will go ahead and pass it off to Jiyae.
Thank you so much, Dustin. All right, so let's dive in to the E-2 visa requirements, and we'll do an overview of what the requirements are. So, as we mentioned, the E-2 visa is a visa for entrepreneurs. So, in order to qualify for the E-2 visa, the first requirement is that you must be a national of a treaty country. So, what does it mean, a treaty country? So the E-2 visa is an option available to nationals of over 80 countries that have signed an economic treaty with the United States, right? And this includes many countries in the world, in all continents, including, countries like Canada, Mexico, UK, New Zealand, Singapore, Jamaica, Philippines, just to name a few. Now, it is not available for nationals of certain countries that have not signed such an economic treaty with the United States. And some of the well-known examples of non-treaty countries include India, China, and Russia, which do not participate in the E-2 visa program. However, if you are a dual national of a non-treaty country and a treaty country, it is possible that you can use the treaty country's passport to apply for the E-2 visa. The second requirement is that of majority ownership. So the E-2 company must be at least 50% owned by nationals of the treaty country. And that is how the nationality of the enterprise is determined. And this is also related to the develop and direct requirement, where the treaty country national, by owning 50% or more, demonstrates the person's ability to develop and direct the enterprise. The other requirement is that a substantial investment must have been made. And let's dig in a little bit more on what substantial investment means. So, when we speak of investments, we speak of funds actually being placed at risk. Now, what does it mean that funds are placed at risk of loss? So, we do get, some questions, right, from people who are wondering, what if I, create an entity, a US LLC in the United States? Let's say I create a bank account for that LLC, and let's say that I transfer let's say $100,000 from my personal bank account into the LLC's business bank account and say, okay, this is my investment. Is that really investment? Now, as the US government understands it, this would not actually qualify as an investment because simply funds sitting in a bank account may also be very easily taken out by you, especially if you're the 100% owner of the LLC. So really, in reality, in practice, no funds are actually being placed at risk of loss if it is simply sitting in a bank account. By contrast, what the government is expecting to see in the context of a startup business, for example, is actually funds being spent on, tangible resources such as a commercial lease. You could pay the security deposit and the first month's rent. You could, go ahead and hire employees and pay, towards employee payroll. You could also purchase equipment for the business, or you could purchase things like inventory that is necessary to get the business up and running. And those concrete expenditures are considered funds placed at risk because you have actually spent money on things that your business will need to become operational. If you are purchasing a business, one way you can meet the at-risk requirement is if you place the purchase price to a third-party escrow account with the sole condition of the escrow funds being released to the seller being the approval of the E-2 visa. So what that means is that there should be no other conditions for the sale to become consummated outside of the approval of the E-2 visa, which can be a condition, but only if it is the sole condition. So this is what we mean when we speak of funds being placed at risk. Really, the funds, the investment must be, at risk of loss. If the business, doesn't go well, for example, you will lose money. And that really shows commitment towards the business and really convinces the officer that you really mean to, seriously, develop and direct the business. Now, when we speak of a substantial investment, the exact dollar amount that it is not defined in the regulations or law, but it must be substantial. And we will go into a little bit more detail on what are the considerations when the government is evaluating substantiality of an investment. The other important thing to note is that the applicant must be able to prove the source of funds. We must be able to show where the money came from that was used in the investment. And what the government is looking for is proof that it came from a legitimate source, and it really can be any legitimate source. For example, it can be a loan that you took from your personal property, for example, or an unsecured loan, a line of credit. If you're using a loan, the only requirement is that it must not be secured by the business itself or its assets. So it must be an unrelated secured loan if it is a secured loan, or be an unsecured loan. It can also be sourced from your income from employment, right? And in that case, the government will want to see proof of, such employment income with things like, tax returns, income tax returns, showing that you have earned, in fact, earned that kind of income. Sufficient income that will support the accumulation of that amount of funds. You can also use a gift from someone, and you can provide a gift letter describing where the gift came from. And also, if you're using sources like a gift, it is important to go one step further in the analysis and also show proof of where the gifter earned that money. So, for example, let's say you received a gift of funds from your spouse, and maybe your spouse earned that money from employment income. In that case, you would provide proof of your, spouse's tax returns, income tax returns, for example, that show the spouse receiving such money from employment. Now, the other requirement is that the business must be real and operating. And in the context of a startup business, this means that everything that is necessary for the business to become operational have already been secured. So let's say you are planning to open a gym and applying for an E2 visa based on that plan. When you go into the E2 visa interview, the government will want to see that everything necessary for the gym to open its doors must have been secured. So, for example, all necessary equipment must already have been purchased and set up the way that clients could actually use them. Any, business space lease should already have been secured. The business entity in the United States, the LLC or the corporation, for example, must already have been formed, and the business bank account must already be set up such that the business is indeed ready to open its doors. As soon as you get the E2 visa and arrive in the United States, the business can, basically be up and running. So really, the government is expecting those necessary steps to already have been taken by the time you show up for the interview. Now, the other requirement is that the business must be one that will eventually hire US workers. Now, it is a very important requirement, and this is also called the marginality requirement, in that when you apply for the E2 visa, the government is expecting something more than just a one-person shop. So they're looking for a business that will hire at least several workers, if not immediately, at least by year 5 of operation. We want ideally to show 3 to 4 full-time employees being employed by the enterprise. That is the operational scale that the government is looking for when they are adjudicating E2 visas. And it kind of makes sense, right? Because if you look at the purpose of the E2 visa, it is really to encourage commerce and investment. So job creation is definitely a big part of that. Now, the last requirement is that the applicant must be able to show an intent to return to their home country if the E2 status ends. As I mentioned before, the E2 visa is a non-immigrant visa, and as such, the applicant is expected to provide a signed statement of intent. Describing that their intent is to run the business, and after the business project is over, that they do intend to return to one's home country. All right, so let's go over the options and timing for obtaining an E2 visa. So there are two options. If you look at the overview, the first option is you can start a new business in the United States, start a business enterprise from scratch. The second option is you can purchase an existing business in the United States. So if you are starting a business in the United States, the investment, as I mentioned, is anything that you spend, any money that you put towards setting up the business to the point that it will become ready to be operational. If you are purchasing an existing business in the United States, the same considerations would apply. Now, the investment would consist of the purchase price that you will be paying. And in the purchase context, one way to meet the at-risk requirement, as I mentioned before, regarding the investment, is that you can use an escrow account. And that is one way you can maybe hedge against the risk that, maybe the E2 visa application may be denied, and maybe, you would want to pull out of the sale. And what the government permits is if the E2 visa approval is the only condition for the funds in escrow to be transferred to the seller, it is permissible to use that kind of arrangement, the escrow arrangement, to consummate the sale. If there are any other conditions other than that to consummating the sale, then that may be a problem for the at-risk requirement. But as long as the only condition for the escrow funds being released is the E2 visa approval, you are allowed to use that structure to mitigate such risks. Now, let's talk about for how long is an E-2 visa valid? And that length really depends on the country of nationality with which you are applying for the E-2 visa. And you can look this up actually. Google, reciprocity schedule, Department of States, and you can go through the country of nationality and the variable, visa lengths are listed there. You can look up the length of how long the visa will be issued. The length of the visa issuance can also depend on the consular officer's discretion. So, for example, for nationals of Canada, for example, you would typically get a visa that is as long as 5 years. But let's say the officer has certain doubts about the application. So, let's say maybe the officer is not really sure if the business will reach that part of, non-marginal revenues or non-marginal hiring based on the information that is initially provided. And in that case, it is also possible for the consular officer to issue the visa for a shorter time period because they may want to see you again in not in 5 years, but maybe in 2 years, maybe in 3 years, and see updated documents about the business's performance to really see if the business is, non-marginal as required. So it is possible that the officer could use his or her discretion to issue the visa for a shorter period of time, in which case you would need to come back to renew it sooner than you may be expecting. Now, the other thing to go over before moving on to the next slide is that the length of the visa validity is a different concept than the length of authorized stay that you get every time you use the visa to enter the United States. And one easy way to think about it is that the visa is kind of an entry ticket. You use that to gain admission to the United States in E-2 status when you're coming into the US. Now, the validity of the visa is pretty much the validity, you can think of it as the validity of a ticket, right? So you present the visa to gain admission. And once you gain admission at that particular date, for an E-2 status, you get 2 years at each entry to stay in the United States, developing and directing your E-2 enterprise. And so for some countries, the visa validity period of the visa itself, it can be quite short. For some countries, it is only a 3-month valid visa. And what that means is within those 3 months of visa validity, you use that to gain admission to the United States. But once you are gained admission, the period of authorized stay that you get in E-2 status is going to be 2 years. So you don't need to leave, once your visa is expired. The authorized period of stay is dependent on the expiration date that is written on your I-94. So it is very important always to be checking your I-94 at each entry in the United States because the I-94 expiry date governs your period of authorized stay, and it can be different from the actual visa validity period. All right. So now let's shift gears a little bit and talk in a little bit more detail about the substantiality of investment. Um, and it is very important to understand how substantiality is assessed in the eyes of the E-2 visa consular officer. So the important thing to know is that there is no hard set minimum dollar amount that is required under the law or regulations. The requirement is that the investment must be substantial, and the amount of what amount of investment will be considered substantial, it depends on a couple things. So the first thing to keep in mind is it'll depend on the type of business. So if you are setting up a consulting type, service-oriented business, for example, that may not typically require high startup costs, you may, simply need an office to, see clients. You may be hiring a couple of employees. You may, you may be buying, computer equipment to provide those services, for example, and, purchasing a lease for an office space. So in that kind of situation, the expected amount that will be considered substantial will likely be lower than comparatively, let's say, a retail type business or a restaurant where maybe much more complicated machinery or equipment is needed. A manufacturing type business, which may require, millions of dollars of upfront investment. If you're setting up, a retail operations, you may want a larger upfront investment on inventory, for example. So really, what amount of investment, what dollar amount of investment would be seen as substantial will depend very much on the type of the business. Uh, the other consideration is where you apply and the examiner. So certain consulates around the world have a higher threshold that they are working with when they look at E-2 applications. And so it is very important to work with a lawyer who is knowledgeable with regards to those nuanced differences so that when you are going to a particular consulate, you know that you are meeting the expectations of the officers that are used to seeing in when they're adjudicating E-2 cases. Finally, the other element is that the overall strength of your case is very important when we speak of the substantiality of investment. So let's say even if you only put in, $80,000, of investment towards a business, let's say, but maybe you can show other stronger types of evidence that that was actually enough to get a business up and running because let's say your business is already earning revenue. Or let's say you've already hired employees and you already have multiple client contracts showing how the business will actually be effectively meeting client expectations, client contracts, um, and even be, showing, a positive cash flow month to month. If you have very strong evidence of, other elements such as marginality, real and operating, and things like that, it is also possible that you may be able to qualify for substantiality with a lower dollar amount. So really, a holistic assessment of the facts of your case will be needed to, really determine whether a set amount of investment is enough. It is a really fact-specific analysis on what dollar amount would be enough for substantiality. Now, let's talk a little bit about the proportionality test. So what the proportionality test means is that the smaller the amount of total capital that is needed to get a type of business up and running, the higher percentage of that amount the consulate will expect that was already spent. So, and an easy way to think about this is comparing a smaller startup that only requires like you know, any amount below, let's say, $400,000 to set up, the consulate would likely expect 100% of that amount to already have been spent, as opposed to a case where a larger enterprise that would be of a 10 million value, for example. But even if spent 1 million out of the 10 million, that may just as likely be considered substantial, even though it is only 10% of the total value of the business that is being set up, just because the total dollar amount of the business value is so high. So it is kind of a reverse proportionality test with the size of the business that the government will expect that you have already invested by the time you apply for the visa. By buying a business, when you're buying a business, substantiality is determined by the purchase price and comparing that with the fair market value of the business. So if you purchase a business from the open market, you likely have already paid the fair market price for that particular business. So the purchase price will equal the fair market value of the business, and that will meet the substantiality requirement. Now, the issue is when you are buying a business from someone that you know, so it's kind of a closed transaction, or even a related party transaction. And those types of transactions are much riskier, right? So if you are purchasing a business in the closed market situation, then what can be helpful is to get an independent CPA to provide a valuation, an assessment of the value of the business, the fair market value of the business, such that you can show to the officer that you actually did pay the fair market price. of the business. And that would be the way to defend the substantiality argument. Now, two more points to make. Franchises can be a very good option for E2 visas, especially when you think of the substantiality of the investment, because any funds that you pay towards securing the franchise rights can also be used towards your investment amount. Also, the resources that the franchise can provide, such as help with marketing, and the intellectual property and know-how and things like that, could also support your arguments for real and operating and marginality, given, some of the traction that the franchise has had in the industry. So that can definitely be a good way to explore an E2 visa. There are some common good and bad E2 visa expenditures. Not everything that you spend towards setting up a startup can be used as an E2 visa expenditure. So, for example, things like meals or transport fees. If you're flying to New York to you know, look at some business leases, and you try to claim the airfare that you use to travel to New York, things like that. Those are considered not ideal types of expenditures to include as part of the investment. Good expenditures, by contrast, are, the types of expenditures that really relate to what is necessary to set up a business. So things like, you know, um, setting up the entity, fees that is, registration fees to set up the LLC, things like that. And, securing a business office lease or buying equipment that is necessary for a business. So really always be thinking of the business need and the directness of the connection to, the actual needs of setting up a business when we speak of expenditures. All right. Do I have to hire employees? So that is a very common question that we get from clients and potential clients, and the answer is a definite yes. The E2 business must have either the present or future capacity to generate enough income to provide more than a minimal living for the investor and their family. And this definitely means the ability to hire US workers and actually hiring US workers once you are granted the E2 visa and are running the business before you go on to the renewal stage. So when you are applying for an initial E2 visa, you must demonstrate that you will hire employees in the next 5 years in your E2 business enterprise. And our recommendation is to hire at least 3 to 5 full-time employees over the 5 years of operating your enterprise. And one thing to note is there is a distinction between W-2 employees versus 1099 contractors. It is more preferable to use W-2 employees to show this hiring. W-2 employees are what we mean, regular employees, when we speak of employees. If you're using part-time employees, when we speak of the 3 to 5 employees, we're speaking of full-time equivalent. So if you're using part-time, then you can multiply the number to get to that calculation. 1099 workers can work on a case-by-case basis. It will really also depend on the practice of the industry. So, for example, in certain types of industries, such as food and drink, for example, maybe it is the industry custom to use a high number of 1099 workers, to hire a high number of 1099 workers instead of using W-2 employees. And in that case, it may be permissible to, show marginality by showing a high number of 1099 workers. So definitely work with your lawyer, and we can look at the facts holistically and advise on, the strength of your marginality argument when we're working on a renewal. How do I prove hiring? So, if you're applying for the initial E2 visa with a new business, the business plan is a very important element of proving marginality. The business plan will include a detailed hiring plan and also a detailed, financial statement, profit and loss projected statements that will show that your business will be generating enough income, enough revenues to support the hiring of those employees. Client letters of intent can be very helpful to show that there is actual demand in the business's products or services in the United States by the time you apply. Um, that can be a very helpful element to show marginality, to meet the marginality requirement. For existing businesses, especially in the renewal context, it is very important to show a record of Form W-2s. You file them every year that your business is running at the end of the year. Pay stubs can also be helpful evidence that you have been paying, particular amount of salary to your workers. Tax returns are also a very important key piece of evidence in the renewal context. Tax returns for your business income would show that your business has been making the required scale of revenues and profits to show that it is a going concern and that the scale of the business income is not marginal. All right, so the last topic I will cover before handing it off to Dustin are the business plan considerations. The business plan is a very important element in initial E-2 visa applications, and there are a couple of things that the business plan should contain to be an effective help for your case. So the business plan should typically contain an executive summary in the first page describing concisely who you are, what you do, who do you sell to in terms of your business. This is important because when the officer is flipping through your case, it is the first thing that they will see. So it is a very good strategy to make sure that the elements of the business is clearly understood from the beginning. Market analysis and research can be helpful to include to show the context of where your business will be operating. What is the business opportunity that you see? Is there a real need for the provision of that kind of service or product? A marketing plan is also a very important element. You can outline some of the strategies that you will use to gain new clients, build client pipelines that will support that the business will actually achieve what it says it will. Um, Personnel plan is what I mentioned in the previous slide, very important for marginality purposes. We recommend adding a table of the next 5 years of hiring projections with a description of the positions that you will hire for, how much salary each position will make, and how many employees per position you would be hiring, and what role would those employees play in the overall operation of the business. One of the requirements for development direct, for example, is that the applicant is expected to play sort of a managerial executive role on top of the business as opposed to doing, the productive labor on the ground. So you will need to show that there will be enough employees to take care of those productive tasks for you. Um, Comprehensive financial plan is a very much of a key element of an effective business plan. You want to be able to show 5 years of financial projections that is very detailed and persuasive. It can include a balance sheet and an income statement, a profit and loss statement, which shows, the expected scale of revenues and expenses and profits, kind of a breakdown of how the business will operate, and also a cash flow statement if appropriate.
Great. Thank you very much, Jiyae. So we will switch over to a few considerations, some of which Jiyae has already mentioned. The first is you have the option of applying at USCIS or a consulate if you're inside the US. If you're outside the US, you must apply for the E-2 visa at a consulate. So if you're inside the US and you have the option of applying between USCIS and a consulate, how do you decide between the two and what are the pros and cons? Basically, our general recommendation is to apply at a consulate. And the reason is that only a consulate can issue a visa. USCIS can only grant you status. So I know there's a question here about being in the US on a visitor visa and wanting to change status to an E-2. That would be done through USCIS. And if you're approved, you would get E-2 status, meaning you can stay in the US for a defined period of time, up to 2 years, and which you can renew. and you have work authorization once you're approved to work at your E-2 company. However, the moment you leave the US, you abandon your status. Okay, and you need a visa to come back into the US in E-2 status. So, because of that, because the moment you leave the US, you're going to need to apply for a visa anyway, we do generally recommend that you apply at a consulate, get an E-2 visa so that you can enter and exit the US uh, flexibly. An E-2 visa, Jiyae mentioned, they can be issued for different periods of time, and that depends on your country of nationality. The maximum period of time is 5 years. So if you are from a country that does have a 5 year period, such as Canada, the UK, many countries have a 5 year validity period, you can enter and exit multiple times over that period. If you're from a country with a shorter period, they can be as short as 3 months. Then applying within the US could make sense. But we work with our clients individually based on their circumstances to help them figure this out. So, what are some other benefits of why would someone apply through USCIS? So, the short validity period is one reason. The other is that USCIS tends to allow lower investment amounts. So, if your investment amount is say under $50,000, most consulates are going to have a hard time with an E-2 visa that's under $50,000 investment. USCIS, though, we do see approvals below $50,000. They would still be considered risky cases, and we would have to do what Jiyae mentioned in terms of looking at the application holistically and strengthening it in various ways. But your odds are higher in general applying through USCIS if you have a low investment amount. On the other hand, USCIS is going to closely scrutinize the source and path of your invested funds. So if you have spotty documentation, if you are using cryptocurrency that doesn't have documentation, then USCIS could be riskier than a consulate. Um, the other thing I will say, the final note I'll make on this is actually two notes. First is not all consulates approach E-2 visas the same way. So some consulates are more flexible than others. The other point I'll make is if you are inside the US, sometimes it makes sense to file both of these applications at the same time. So let's say that you are in the US as a student, you're studying accounting, and you want to start an accounting firm. Um, let's say you're from a country where the consulate has a long backlog, so they're taking a long time to review applications. If you're in the US, you can file a change of status application through USCIS at the same time that you file the application at the consulate. What that does is you get in line at the consulate. So once they get to your application, which could be months down the road, they'll let you know. You'll fly to the country, you'll interview, you'll get your visa and come back in. And in the meantime, you filed with USCIS. You do have the option of paying an expedite fee with USCIS. It's called premium processing. It's not cheap. It costs $2,800. But if you pay that, they will guarantee you a decision within 15 business days. So you're in the US in F1 status, you can file that change of status application with premium processing and potentially be able to start running your accounting firm within 15 business days of applying and operate the company for the several months before you go to the consulate to actually get your visa. The next item, source and trail of funds. I already mentioned that USCIS closely scrutinizes this, but the general requirement is that your personal investment needs to be from a lawful and legitimate source. So that is frankly, it's a very lenient standard. You can use funds from almost any source as long as it's lawful and legitimate. You can use gifts from pretty much anyone as long as they have documented where they got the money. You can use loans as long as they are not secured by the E-2 company. You can even use unsecured loans like a credit card as long as it's your personal credit card and not the company's credit card. So the source of funds can be quite broad, but you do need to document exactly what the source is and how the funds traveled from the source all the way to the E2 company. So considerations for small investment amounts. We actually have a separate presentation that's a webinar that's specifically on what we call risky E2 applications. And in general, what we consider risky applications largely are low investment amounts. But that being said, we pride ourselves on actually having a quite successful track record, helping clients who don't have, say, $100,000 to invest. They may have $60,000, $70,000 to invest, sometimes even less. Those are risky cases, meaning the possibility of denial. But there are ways to strengthen those applications. And of course, past results don't predict future outcomes, but even the founding of our firm was on a relatively low investment amount. So like I said, there's a full-length webinar. Do check it out on YouTube or sign up for it. We will be presenting it again soon. In the meantime, for now, I'll just touch on a couple things you can do. One is to get letters from prospective clients who are talking about how they look forward to hiring you, to buy goods from you, or to hire you for your services that you're offering. Include those letters in your application to show that there's real demand for your company, for your goods and services. You can also include a letter from a CPA, certified public accountant, where they are talking about, based on their experience, you have invested a sufficient amount to start your type of company. So, for example, if you're starting a consulting company and it only takes $50,000 to start your company, and that's what you've invested, a letter from a CPA saying, $50,000 is sufficient to start this type of company could be sufficient. I'll just quickly add, if you can hire US workers, that significantly strengthens your application if you have a low investment amount, and is probably the best thing you can do for your case is to hire someone. Even if you're outside the US or if you're inside the US, having someone who is actively working at the company. If you don't have work authorization, it should not be you, but you can hire someone else to run the company. That can be a wonderful way to show the government that in spite of a low investment amount, you're already generating job opportunities for US workers. Next, you can get an E-2 visa for two investors. The requirement, if you recall, Jiyae mentioned, is that the E-2 investor must own at least 50% of the US company. So that means two investors can each own exactly 50%, and they can qualify for the E-2 visa based on that. They can satisfy the nationality requirement and ownership requirement based on that. An interesting point on this, GA mentioned before that determines the nationality of the company. So if you are a national of Canada, you own 100% of the company. That company can hire E-2 employees from Canada if they qualify. If you have two E-2 investors, let's say one is from Canada, one is from Germany, that company has dual nationality and can hire E-2 employees from either country. So that is an interesting aspect of the E-2 visa. I'm not going to say too much about substantive changes to the business after filing. This is a gray area. In general, what this means is when you apply for an E-2 visa, you tell the government what the company's going to do. You'll tell the government, for example, I'm going to start a restaurant in the US. If you decide to open a coffee shop under the same LLC, is that a substantive change? We would say probably not, because you're already operating a restaurant. Starting a coffee shop is probably fine. But what if you decide to start selling outdoor clothing under that same LLC? That is probably a substantive change, since you told the government you're going to operate a restaurant. So if you want to change the scope of your business from what you represented to the government, you should consult a lawyer. We're happy to help with that. Sometimes you'll need to apply to USCIS for an amendment where they say, we acknowledge you're changing the scope. It is okay to do that. Sometimes they will say it's not okay to do that. You need to get a new visa or submit an entirely new application. So at the beginning, hopefully the people on this call by and large have not filed their applications yet, but the recommendation is at the beginning, expand the scope of the business. Say in your application, I'm going to start a restaurant, and in the future, we plan to sell outdoor clothing under the same LLC. And then the substantive change becomes a non-issue because that was your representation to the government. And finally, there are some innately higher risk cases, and these generally tend to be companies, businesses, or business types where the government is skeptical that the business will employ US workers. If the government does not think your business is going to employ US workers, you're almost certainly going to be denied. Conversely, if the government thinks you will employ US workers, you're very likely to be approved, even if you have a low investment amount. So there are certain types of business where the government just doesn't think these types of businesses employ workers. One is real estate investment. You're buying property, hoping that it will appreciate in value. Maybe you're improving the property and then hoping to resell it. Maybe you're flipping homes. The second is equity trading, where you're purchasing, say, stocks or equities, hoping that they appreciate. These types of companies, you can be approved based on them, but you need to make it clear in your application why you'll need to hire US workers. So in the case of flipping homes, if you are going to flip one or two homes, the government's not going to believe you're going to need employees. If you're going to be flipping a portfolio of 20 homes, then there is an argument that you actually need a staff to do this, and you're going to have W-2 employees. So the final category is family business purchases. Jiyae mentioned the fair market value. If you're buying a business, just make sure you're paying the fair market value, especially if you're buying from a family member. Don't accept a discount. The reason is the government's going to come back and say, you did not pay a substantial amount for the business. You got a discount, and you don't want that to happen. Common reasons for E-2 denials. Low investment amount is a very common one, so bolster the application in other ways, such as by hiring employees before you apply. I mentioned the nature of the business. Sometimes real estate or equity trading companies can be risky. The filing location or venue, as I mentioned, USCIS is very strict on the source of funds. Consulates tend not to be. Consulates do tend to be stricter on the investment amount, and some consulates look for a much higher investment amount because they're used to seeing larger companies apply for E-2 visas. So we help our clients navigate that and figure out which location is ideal. Now, this became more difficult recently because the government now requires that you apply at the consulate of nationality or in the country where you reside. So you can no longer kind of choose the consulate if you don't have ties to that country. Another common reason for E-2 denials is if you operate a similar business in your home country that hasn't employed US workers. So let's say your E-2 company is going to be a consulting company. You've had the same type of company for the last decade in your home country, but you haven't had any employees. It's just been you working there. That is going to create a risk because you'll then have to start your interview and your application by explaining away why you're not going to do the same thing you did abroad, why this time around you're going to have employees. So it's not impossible to overcome, especially if you have already hired a worker in the US, but it's something to be aware of. This is a risk. Sometimes the adjudicating officer just is in a bad mood or just does not want to approve the case, even though it should be approved. Unfortunately, officers do have complete discretion on these applications. You can reapply though, and oftentimes consulates will assign your application to a different officer the second time around, which is a positive. And finally, sometimes people come to us after they have been denied, and we look at the application they submitted and they just didn't meet the requirements. They may not have 50% ownership. They might have all of their money sitting in the bank account, not spent. So do make sure that you have met the requirements. So how do you renew an E-2 visa? In general, you want to hire US workers. So you want to show that you have employed and are employing US workers at the time you apply. Ideally, you'll have between 3 and 5 full-time equivalent US workers at a minimum at the time you reapply. And you also want to show that the business is doing okay financially, meaning it's generating enough revenue and profit to support both those workers, the US workers, as well as the owner and their family. So you don't need anything extravagant. We're not talking 10 or $20 million, but we're talking about at the end of the day, the owner is able to take home 50,000, if they have a family, 60,000, enough to support themselves and their family. And some things that may come up at renewal, make sure your ownership is always at least 50%. If you sell equity, don't allow your percentage to drop below 50%. You become immediately ineligible if you do that. And be careful if you're changing the scope of the business, as we talked about before. Some recent developments. E2 visa approval rates are still high. They're still in the 80% range. Generally, our firm has a much higher approval rate in the high 90s. That's not a prediction of future outcomes, but that is our track record. We've recently seen that consulates want to see that the majority of the investment is spent inside the US. So, for example, if you have a company that buys products in China and resells them, do make sure that at least half of your investment is spent in the US. It's okay if you buy inventory in China, but if you're buying let's say you have $100,000 investment, don't spend more than $50,000 in China. Also, the government may want to see higher investment amounts. Recently, that's been a slight trend, though we are still seeing success with lower investment amounts. Um, Focus on employees rather than contractors. Jiyae mentioned that 1099 workers, i.e. independent contractors, they can be okay based on the industry. Construction is common, but they are relatively weaker than employees. The government wants to see that you have regular, consistent employment of U.S. workers. Um, Wait times at consulates is much better than during the COVID pandemic, though you should still expect several months, meaning typically 3 to 6 months, depending on the consulate. And sometimes the government will put applications in administrative processing. This is really security screening. Nothing you can do about it. And fortunately, this is still rare. It is the exception rather than the rule. And oftentimes, administrative processing will be fast. Sometimes these are decided in a week or two, but there is the occasional case where the government takes a month, 2 months, or even longer reviewing the application. And they'll oftentimes send it to Washington, D.C. to review it. So that can be frustrating. Again, it's the exception. So hopefully will not impact your application. All right, I know some great questions came in. So can training be required for starting the business? I think this is asking, can training be included in the investment schedule as an expense? The answer is it can be if it is specific to the E2 business. So in other words, if you're starting a restaurant in Florida and Florida requires that the owner do a training in Florida on health, you might be able to include that. Otherwise, if it's general training for yourself, so for example, your education, you cannot include, you should not include, only include it if it's specific to the business. This is a longer question. I'm going to hold off since I know a number of shorter ones came in. Do we share all evidence at application time or during the interview? That is an excellent question. It really depends on the consulate's instructions. Some consulates want to see an entire application packet beforehand, such as London. Other consulates want you to simply submit the DS-160 online form and a skeletal application, and then to answer questions during the interview. In general, the application that's submitted to the consulate is going to include the vast majority of the evidence. So you will submit it beforehand. You definitely should qualify for the visa at the time you apply. So in other words, you need to make your investment before you submit your application. The business needs to be ready to be operational at the time you submit the application, not at the time of interview. Both at the time of application and at the interview. Can lawyer fees be considered an E2 expenditure? Yes, they can. Though they are a relatively weaker expense. So if you're investing $40,000 and $20,000 are legal fees, that's going to be a problem. It's fine to include legal fees, but you want the vast majority of your investment to be inventory, equipment, paying employees, things the business really needs. E2 visa for Spain will be for how many years? What you want to do is Google E2 reciprocity, go to the Department of State website, click on Spain, click on E2 visa, and you'll see exactly how long it is. I'm not going to do that right now.
Oh, I
But if
looked it
you,
up.
oh, great. What
Apparently,
is it?
apparently it's 5 years, 60
Excellent.
months.
5 years.
Yeah.
That's good news for you. All right. So, can we use token-based real estate investments for E2 visas? I have no idea what a token-based real estate investment is. If you mean cryptocurrency, Uh, as long as it is fully documented, um, it can work, but you definitely don't want there to be any gaps in the documentation. Gia, do you know what a token-based real estate investment is?
No, but I actually am more concerned about the real estate investment part, right? And
Yeah,
Dustin, you went over the risks of, real estate-based investments for the E2 visa because there is possibility the government can think it is a passive investment, gearing towards, just a generation of appreciation and value instead of being a real and operating business that provides goods and services. So
yeah,
real estate-based companies, very risky. Definitely get in touch with the lawyer.
yeah.
Get in touch with us with a consultation, and we can provide more specific guidance.
Right. And that, I mean, you're adding to the real estate investment a token base, which if I don't understand it and I see dozens of these applications, there's a really good chance that the government official is not going to understand it. So be careful. If they have any doubts, they will deny. All right, let's go back to this longer one. I transferred money to my cousin 2.5 years ago. Can I use that toward my business? Well, if your cousin gifts you back the money, potentially, but why don't you schedule a consultation so we understand exactly what happened there? It's hard to understand during the webinar. I'm already in the
Yeah.
US on a B2. Is it possible to get a change of status? It is possible as long as you qualify for the E2. The other thing you want to be careful of. You do not want to just come into the US and immediately apply for a change of status. The government is going to can accuse you of misrepresentation if you do that. So just don't do that.
The other thing is you will need a visa to travel back and forth freely. I think that's the last question
Yes.
that you asked.
Yes.
This change of status will only grant you status for that particular visit. So as soon as you leave the US, you'll need a new visa to come back in. So you will need a
Mhm.
visa stamp to do that.
Perfect. Yes. Um, so this next question has a lot of specifics about the company, how it's doing for a renewal. Schedule a consultation, please. We'll talk about the specifics of your circumstances. This next question is great. UK residency requirement. So the United Kingdom is the only country, one of the only, I believe it's the only one that requires that you be a resident of the UK in order to qualify for an E2 visa. Every other country, you just need a passport from the treaty country. So the UK residency requirement is enforced, but there is some flexibility. So, for example, if you've been in the US on a student visa for several years, that is not time that's going to count against you. So they will look at the last time you lived outside the US. And if that was the UK, probably not a problem. If you lived in the UK 5 years ago and moved 5 years ago to the UAE, then it's probably not a problem. 5 years is usually okay, but after that, you start getting into 6, 7 years being outside the UK, you might start having issues. So we're happy to work with you on that. For getting a new E2 visa, I would like to learn more. I hope the webinar was helpful. Schedule a consultation if we can answer any questions. Can you stay on a valid I-94 and an expired visa, or is that looked down on? That is perfectly fine. So GA said, when you enter the country, the visa is basically irrelevant. All a visa does is allow you to request entry into the US. Once you're inside the US, the I-94 is entirely what controls how long you can stay. So just make sure you leave before your I-94 expires, or you apply to extend your status before your I-94 expires. Can consulting fees or attorney fees be included? They can be. What if I intend to invest $30,000 cash now and plan to invest 40,000 and it makes sense, but you need to wait to apply. So you need to make your investment before you apply for the E2 visa. I'm a CPA licensed, recently formed in Dallas. Okay. Can I skip applying in London as the wait times are very long? Can I head out of the States on a 3-month tourist visa and some? So this is what I was mentioning before. You do not want to enter the US on a tourist visa for the purpose of changing status. So your intention when you enter needs to be to enter in the status you're entering on. So schedule a consultation if you have questions about that. That
Yeah,
can be risky.
jumping in with another
Mm.
thing is that if you're coming in on ESTA, you can't change status. So you'll
Yeah,
need to be on a B1, B2 visa in order to be able to change. But ESTA, you can't, change to E2 if you came
correct.
in on an ESTA.
That's a great point. Um, If we file for a change of status to E2, can we operate or run the childcare business while the application is pending? Excellent question. Definitely no. You cannot work for the E2 company until your status is approved. If you start working for it before then, you are working without authorization, and that is going to be a really big issue, especially in the current administration. So do not do that. Wait until you're approved, or wait until you get your visa and enter the US on that visa. In case of a change of status, do we need to wait till 90 days? So that's come up a few times. Your intention at the time you enter should be to have the status you have. You should wait some time. Your intention should be legitimate. If your mind changes 90 days after you enter, that's probably fine. But schedule a consultation if you have questions. Regarding an existing business, okay, schedule a consultation to talk about the circumstances of your situation, please, regarding the investment and whether the application's viable. Can a change of status for E2 and B1, B2 be applied at the same time? That is an odd question. So a change of status is only sought to change your current status to something else. So there really is not a point in applying simultaneously for a change of status because you're only going to be approved for one. So I would not recommend a simultaneous change of status. Can three siblings from three different countries invest together and buy a business? So you need to own at least 50% of the business. So only a maximum of two E2 investors can apply based on a single business. Transfer of money should be after the specific waiting time. I think this is about the change of status. So transfer of money does not really matter. You're not working. So you just need to invest in the business before you apply for the E2. E2 renewal requirement change under Trump. There really hasn't been a change under Trump. As long as you show you're employing US workers and generating enough income and revenue and profits to support the workers and yourself as the investor, you're probably going to be approved. Can I set up a US bank account for my new business without a US address? Can the company be registered in the US without a US address? So really, I think what this is getting at is if you're outside the US, can you start a company in the US and can you open a business bank account in the US? And the answer is yes, you can. You can form an LLC or a corporation in a state, even if you don't live in that state, or if you're outside the US, you may need to have a registered agent in the US, but there are plenty of companies that do that. And in terms of opening a bank account, you'll really just need to talk with the banks and what requirements they have. But we are a few minutes over. I do want to respect everyone's time, but thank you all for the excellent questions. If you do want to talk about your situation, schedule a consultation. We're happy to talk through that with you. We hope to see you on future webinars. Keep an eye out for our email, and we hope the resources we put out for free as well on our YouTube channel and our blog are helpful. Jiyae, thank you so much for sharing your expertise. Everyone have a wonderful day and stay well. Thank you.
Thank you.